Okay, looks like we're online. I'll go ahead and call this to order. Welcome to the Police Oversight Commission, Thursday, August 14th. If you please join me, stand and say the Pledge of Allegiance. I pledge allegiance to the United States of America and to the Republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, thank you. Next on the agenda is the approval of the agenda. Are there any comments on the agenda?
I would like to withdraw 4714, or have Commissioner move to withdraw that as it was heard last month.
Okay, IRO, I'm gonna have you talk into the microphone. That wasn't coming through very clear to me.
I would ask that a commissioner move to withdraw 47-14 as it was heard last month.
Okay. I will move to remove 47-14 from the agenda. Is there a second? Okay. Any discussion? All in favor, please say aye. 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 Okay, that's unanimous. So that'll be removed from the agenda. Any other further changes to the agenda proposed? Okay. Actually, I would propose moving. I think the way this was going to work out is CDC 112-12 be moved from non-concurrence to the consent agenda. Does that sound right, IRO?
Commissioner Foster indicated that he would like to leave it on the on the non-concurrence agenda.
Okay, that'd be fine. I'm fine with that. Okay, so no further changes to the agenda. I move to approve the agenda. Is there a second? Second. Any discussion? Okay, all those in favor of approving the agenda with the amendment, please say aye. 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 Okay, that is unanimous. Next on the agenda, public comments. I don't have a list of the speakers signed up to speak, so if Commissioner Foster could help us out there.
Actually, Commissioner Barker has the list.
The first public speaker this evening is Tony Perrard. I think he understands, Tony, you understand the ramifications or the requirements. You get 3 minutes. And
okay, while the first speaker's coming up to speak real quick, let me ask the other commissioners if you could take special care to speak into the microphone. I'm having a little bit of difficulty hearing the both of you as well.
Very well.
You may begin.
Thank you. It's time to clean house, ladies and gentlemen. The POC should be officially dissolved. I have several models of citizen oversight which I'll share with people who are interested. I would say goodbye to Robin Hammer, and don't forget to take your gang of traitorous corporate mercenaries with you. You and APD have cost the taxpayers too much. There will be no more shootings passed through the Citizens Committee. The corruption ends now. There will be a smooth 4 to 6 month transition period as citizens become familiar with their new settings. Robin Hammer's extortive salary will be divided up among the 5 new citizen board members. The new PPOC, which will be People's Police Oversight Commission, will consist of 5 citizens and 2 administrators to handle police internal affairs divisions, police complaints, police gun and assault charges, and complaints of other various serious charges. and officer disrespect. Citizens will have a voice. Only Americans can save America. Wake up, people. America has been taken over by a crooked, corrupt, corporate-owned judicial system whose only purpose is public extortion and provocation. Carrie Brandenburg's house needs to clean up as well. The DOJ and all law enforcement divisions need to cooperate to the fullest. Americans need to be reminded that our elected officials work for us. We are your masters. We are not your slaves. The promotions that are going to go on in Albuquerque APD, well, I can't see promoting cops that molest children, abuse their wives and their kids, abuse drugs and alcohol, both on and off the job. Cleaning house will begin in 2 weeks. For 16 plus years, oversight committees such as these have done nothing to protect citizens. It's time Type 3 and 4 oversight was installed. Citizens will have the right to issue warrants and override a chief's under special circumstances in a new Type 5 oversight commission. Thank you.
Thank you, Mr. Perard. Mr. Charles Arison.
Good evening. Excuse my hat. I wanted to read a little bit from the DOJ's report, findings report. Let's see, I got the right one here, yeah. Well-functioning police department has the trust of the residents it protects, functions as part of the community rather than insulated from it, and cultivates legitimacy when the public views it as engaging with them fairly and representing the rule of law. The DOJ identified several deficiencies in APD's internal accountability mechanisms that contributed to the use of excessive force. The department's lack of internal oversight has allowed a culture of aggression to develop. This culture is evident in the department's training, permissive policy on weapons, underutilization of its crisis intervention team, and overuse of SWAT, and the harsh approaches to ordinary encounters with residents. The lack of accountability and the use of excessive force promotes an acceptance of disproportionate and aggressive behavior towards residents. Independent external oversight of a police agency, oversight that is exercised by individuals or institutions that are not part of or beholden to the agency or its leadership, helps strengthen community trust. To assess the effectiveness of the Albuquerque's external oversight structure, the DOJ interviewed the current review officer and members of this commission. They also reviewed reports of the review officer and recommendations of this commission. They also got other information from other places. From their review, it appears that the review officer is more closely aligned with the department than with the community that the review officer serves. The review officer failed to find violations of department policy in cases where it was more likely than not that violations clearly occurred. The current review officer and her predecessor found very few violations of department policy on the use of deadly force in officer-involved shootings, which is at odds with the evidence. I don't know what that means. Oh, okay, all right. The current review officer and her predecessor have simply been too forgiving to the department's use of deadly force, and they thus deprived the department of critical opportunities to correct its course, which contributed to the overwhelming pattern of unconstitutional use of deadly force that they found. I hope the mayor and the city council are listening, and on Monday the council not only abolishes the current POC in its form, I have one more sentence, but also inform the current IRO that her contract, which is set to expire in a few weeks, will not be renewed. She has simply proven herself to be the wrong person for the job. Thank you.
Thank you, Mr. Harrison. That concludes public forum this evening.
Okay. Thank you to our speakers. Let's see, next on the agenda, review and approval of the minutes. I had one correction to the minutes. On page 3, minutes, under section 8, approval of the IRO review letters. The sentence reads, IRO Hammer requested CPC 6814 and CPC 11014 placed on the agenda and approved. Commissioner Blank moved to grant the request. I believe that was Commissioner Peterson, so if you could add that. You have a discussion on the, well, actually, I move to approve the minutes from the July meeting with the revision that I just made. Is there a second?
I'll second that.
And now, any further discussion or additions or deletions or corrections on the minutes? There being none, all those in favor of approving the minutes from the July meeting, please say aye. Or aye.
Aye.
Aye. Okay, that's approved. Next on the agenda, Citizens Appeal, CPC 210-12.
Chair, I would just ask that you go over the rules for appeal another time.
Absolutely. Yeah. The rules for appeal, basically, Mr. Harrison, I believe you're familiar with, but sequence should be 15 minutes for the appellant, 5 minutes for the police officer present, 10 minutes for APD, 10 minutes for the IRO, and 5 minutes for your rebuttal. That's understood.
Yep, okay. I have some handouts for the IRO and for the commissioners.
Okay, Mr. Eric, I guess we had reached out to you earlier this week to see if there was anything else you were wanting to introduce, and I was under the impression that there was not.
Chair, Mr. Aronson has handed me a stack of documents. Mr. Aronson has handed both myself and the two commissioners present one original document and then pages from the appeal record which the commission had received.
Okay.
In the original document, looks like written of his statement. Is that correct?
Yes. Yeah, so it's just basically what I'm, well, I don't know if I'm going to, it's basically what I planned on saying here today, and some pages from the IRO's investigative file, which I wasn't sure you all had or not. So that's all this is. There's nothing new here. Is that all right?
Okay. Very good. Go ahead and proceed, please.
Okay. Being that I filed my original complaint in this case on October 2nd, 2012, and I now stand here nearly 2 years later, and due to what I can only call foot dragging by the IRO and to some extent the POC itself, I realize that no discipline will be handed out by the chief even if I were to win this appeal. I had planned to aggressively defend my allegations, but after realizing that nothing will be done, and after rereading the DOJ's findings concerning the current IRO and the weak police oversight structure of this commission, I see that it would be an exercise in futility. So what I have done is I have given you gentlemen and the IRO copies of my appeal statement and copies of the pertinent pages from her investigative file, and I simply ask for you to come to your own conclusions. However, I do think it's important that the people know that the IRO knew early on in her investigation that I did have a valid complaint. And by this, I refer you to page 30 of the investigative file, where on November 1st of 2012, which was roughly a month after I filed this complaint, someone inside APD knew that this was a repeated problem and was asking for suggestions that anyone might have to rectify the situation. Also on pages 25 and 28, dated December 28th, 2012, where the IRO's investigator found that the officer in question violated New Mexico Criminal State Statute 66318, which is reinforced by Statute 66615, and that this information is completely missing from the IRO's findings letters to me dated December 13th, 2013, nearly a year later, that you will find on pages marked 49, 50, 51, where she exonerated Officer S of any wrongdoing. There is no doubt in my mind that if the IRO and APD-IA had dinged Officer S on these criminal law violations, it would have had a cascading effect, and that all of my allegations of APD practices and policies violations would have been validated, which would have caused disciplinary actions for not only Officer S, but for her chain of command leading all the way up the ladder to the chief himself. Saying all of this, I plan to move forward, and if nothing else, I would like to know if this situation has been rectified, and if it is now being properly managed and monitored by an assigned city employee. If it has, then this complaint was, at the least, effective. If it has not, has this been done, Ms. Hammer? And if it has, I ask that I be provided the information. That's all I have to say.
Okay, so if that concludes your portion of it, then know that there's any. Well, yeah, okay. Next speaker then.
Acting Lieutenant Medrano will present the presentation from APD.
Okay.
Commissioner Peterson, Commissioner Barker, Commissioner Foster. I'm Acting Lieutenant Medrano for the Alpine Police Department's Internal Affairs Unit. I was not provided the paperwork by Mr. Arison with regards to his appeal reference this particular investigation, but I can comment on with regards to whether or not this was rectified and what procedures have been placed with regards to this particular situation involving the temp tags. On October 11th, 2013, one of our deputy chiefs sent a memorandum to our chief of police at the time with particular concerns on the temp tags and the independent review officer's concerns about it. The deputy chief agreed that the department should do a better job of ensuring that our vehicles are driven with a valid temp tag or license plate. The deputy chief spoke with the fleet manager for our department. He was then informed that there was an issue with issuing license plates on the MVD side. The deputy chief then spoke with a representative from the MVD. It was decided at this time that if there is a delay in receiving a license plate from MVD, then the fleet manager will have the authority to go into a system with the approval of MVD to issue 2 additional temp tags totaling 90 days with regards to having a valid temp tag and driving. But it is their hope from the MVD that it would be streamlined faster. That way the additional temp tags do not have to be issued. The representative from MVD advised that they were looking to streamline it to make it quicker and within a week issuing a license plate for the department. The deputy chief then had the sergeant from Ops Review to prepare what was the information given to him to be prepared to be placed into the SOP as a revision. Now, those SOP revisions state when issued a new vehicle, personnel responsible for ensuring their temporary tag is valid and will notify Operations Review for issuance of a new temporary tag or license plate prior to the expiration date. Operations Review will ensure personnel receive their new license plate or replacement temporary tag in a timely manner. When personnel are notified to pick up a license plate, it is the responsibility of the personnel assigned to the vehicle to ensure they retrieve and sign for the license plate prior to the vehicle's temporary tag expiring. So the deputy chief was able to come up with a solution with the fleet manager and MVD personnel to ensure that our vehicles are registered and are able to be driven on the road. It's also ensured that within the SOP that it is responsibility of the officer who has a vehicle that is waiting a license plate or does have a temp tag that they continue to advise Operations Review with regards to whether it's going to expire or if when they're going to receive their license plate. So for Mr. Arison, this is an SOP revision, so our SOP is online, so he'd be able to retrieve that from the internet. And I can stand for any questions from the commissioners.
Lieutenant, and Mr. Aronson, I'm under the impression that your appeal is in relation to the officer as to whether the officer was in fact operating in accordance with the SOP. Is that correct? So I guess I'm missing it. Why are we discussing issues outside of the fact that the officer either violated the SOP or did not violate the SOP? If that is the problem, and this officer was in violation of state law, my question is why didn't somebody call the Bernalillo County Sheriff's Department to come down and issue a citation to that officer for that information? But the issue that we have is that, as I understand it, is in relation to this officer, whether this officer did or did not act in accordance with the SOP. Is that correct in my understanding, or am I?
The original complaint by Mr. Aronson filed a complaint against the individual officer and Chief Ray Schultz, who is no longer an employee of the Albuquerque Police Department. So we'd have no jurisdiction over Chief Schultz.
I'm sorry, IRI, I'm not hearing you in relation to that. Old age is tough these days.
Mr. Aronson's complaint was about the individual officer, Officer S, and Chief Ray Schultz, who is no longer an employee of the Albuquerque Police Department.
Okay, two things. Commissioner Foster, I'll just ask again, if you could speak into the microphone, that would help me. And then I guess the second thing is, from Mr. Arison's, what he had to say up front there, it sounded to me as though he's no longer appealing it, since that would be futile, according to him. So if we're not actually appealing it, I guess we're more or less just discussing it. So the procedures are such, since the APD spoke, Ms. Hammer, the IRO has 10 minutes to speak if you wish to.
Chair, I would just ask that it be clarified that, in fact, Mr. Aronson is withdrawing his appeal from Mr. Aronson.
Mr. Arison, did I misunderstand that? I mean, this is an act of futility. Are you not appealing it? Are we just kind of discussing it?
Yes, that's true, and yes, And I would like to see this discussed, and I'm glad to hear from APDIA that something has been taken care of here. I'm a little surprised by all of this information, because back in April, mid-April this year, I filed an IPR request for this type of information, and I was told that there was nothing. There was no documentation, no interoffice memorandums, no emails, no discussions with the motor vehicle department, nothing, absolutely nothing. I got 0 pieces of paper. So I'm a little surprised that I'm hearing this now. So yeah. And oh, by the way, this wasn't just against the officer and Chief Ray Schultz. This also had to do with her chain of command, which is written in the SOPs. The SOPs state that that they cannot afford a subordinate to violate any law, state law, federal law, local law, whatever. So this included her entire chain of command. I just wanted to clarify that.
Well, let me ask for a clarification also, Mr. Aronson. So you're saying that you have withdrawn your appeal?
Yes. I think it's an exercise in futility at this point, because so much time has passed, which I don't understand why, when information was readily available within 60 days, 45 days, that are in the investigative file that shows I had a valid complaint, and it took a year before it was brought here, and decided that the officer was exonerated of everything, and then I was given this letter on December 13th of 2013, over a year later, and then I've been shuffled around by the IRO by not giving me the investigative file in a timely fashion, and then by this commission itself because of this thing or the other for the last, well, here we are, what is this, August? 8 months. So
when
I think it's futile. It's futile. So nothing. I can't see you guys bringing it. I won another appeal at one time, and it too was drug out to some extent, and there was no discipline done to any of those officers. So I don't expect there to be any discipline done here. Well, it's futile.
Mr. Aronson, so when did you make that decision to withdraw your appeal? Because we still have it on our agenda as an appeal.
This morning.
And
I asked for some more clarifications from the IRO, and she promised me, this was July 15th. We had a meeting. She promised to get back to me with those clarifications by the 5th of this month. I got clarifications 2 days ago.
So this is in fact a exercise in public forum?
Yes.
Not an appeal?
Yes.
Okay, well, Mr. Harrison, obviously I've been in receipt of your emails and discussions with the IRO. I recognize your frustration and the time it's taken to get to this point, but it sounds as though progress has been made, albeit sometime later. So,
well, may I just say one more thing? Well, again, I did a IPRA request around the 18th of April of this year, asking for any information as far as what the department went through with the motor vehicle department to get this situation rectified. I was told there was nothing, no interoffice emails, memos, changes to SOPs, absolutely nothing. And now here today, I'm hearing a different story. So I'm very disappointed on what's going on here. An IPRA request is law, and that's serious. That's serious business we're talking about here. Now, as I said, I would like to be afforded. I'm pleased to hear that this was effective and that changes have been made, but I think that I did do an IPRA request, And I have been stymied, if you can say that, for the last darn near 2 years on this thing. And I think I should be afforded the information on how all this went together, on how the SOP was changed, and how the department is now operating with the motor vehicle department. Thank you.
Well,
Mr. Aronson.
in an effort
Yes.
to see the glass is half full, I think we'll go with the fact that you're pleased to see that there has been some changes made, and not go with the fact that you're disappointed in the time it took to get here. I think now that since this is no longer an appeal and it's just a discussion, I think this will all be captured in the minutes. I think the information can be given to you after this meeting. So I'll call that a win.
All right, I call that a win-win myself, and I'm glad that that the officer isn't really getting dinged for this, because it's not really her fault. You know, I mean, what choice did she have except to not drive her car for a month and walk, I guess? And then, of course, there is other information in this investigative file that there was as many as 21 cars being driven that way. So this is a serious issue at the time. And I have a feeling that's why it was drug out for so long, because it was basically a Pandora's box. So anyway, I appreciate it, and let's just call this a win-win. And I would really look forward to getting the information. The IRO has my address and phone number. Thank you very much.
Great. Thank you for bringing this to our attention. IRO, you do have the opportunity to speak to this if you so wish. Other than that, we can go ahead and move on.
I just have one thing to say, is that the memo that the acting Lieutenant Madrano read from, referring to the APD's response in resolving the issue, was provided to Mr. Aronson in his appeal packet on page 37, which was from the deputy chief to the chief of police at the time, explaining what the department has done. And acting Lieutenant Madrano referred to that memo and outlined it orally today, but it's been previously supplied to Mr. Aronson, I believe in late March, if not early April of this year, on page 37 of his appeal packet.
So noted. Okay. Well, although it wasn't listed as a discussion on the agenda, we'll treat it as such, and we'll conclude that discussion now and move on to the CPC.
At this time, with the exceptions of CPC 117, 14, and 20312, I would ask that a commissioner request that the CPCs, which have been provided to the commissioners and which will be fully reflected in the minutes, be approved as written on a consent agenda.
I'll second it.
It's been moved.
Any discussion? Okay. All in favor of the consent agenda with the two exceptions, say aye.
Aye.
Aye. Okay, that's unanimous. All right, Ms. Hammer.
With respect to CPC 203-12, I would say that this is a case in which there was a 3-car accident, and the complainant alleged that the report was improperly written and did not accurately reflect what happened. When a review of the lapel camera showed that the investigating officer, Officer H's report was...
IRO,
Yes.
I'm sorry for interrupting you, but I thought we had another appeal.
No. No more appeals. We have non-concurrences. And then there was a PSA that was present who did not record the incident in its entirety. And at the time of this incident in 2012, the SOP did not distinguish between the primary and secondary officers, and at that time all officers who were dispatched or employees, which would cover the PSA, were required to record the incident in its entirety. And so therefore I found that the that the PSA with respect to the lapel camera issue should be sustained. I ask you to adopt approve my letter as written.
Okay. I guess I move to approve CPC 203-12. Is there a second?
I'll second that.
Okay. On the discussion side of this, I guess I'm the one that asked to have this withdrawn from the consent agenda. I guess my question, and I think you spoke to it, was that the SOP at the time made no exceptions for PSAs. My question was, I'm curious why the primary officer recording the incident wasn't sufficient. But I think he spoke to that. Does the SOP read the same now? I mean, if the primary officer is reporting the incident, would a PSA still be required to do so?
Only if the PSA, as the secondary officer, were separated from the primary officer. One recording is required that records presumably the incident in its entirety on dispatch calls for service. And if the PSA were to interview people separately outside the presence of the primary officer, they would be required to record it. But there's a delineation between if the secondary officer is separated from the primary officer.
Okay, so there's no delineation between. I mean, that's the same as the SOP for a primary and secondary officer. So PSAs fall under the same rules.
Yes.
Okay. All right. Is there any further discussion from the other commissioners? Okay, hearing none, there being a motion and a second. All those in favor of accepting the findings on CPC 203-12, please say aye.
Aye.
That's unanimous.
The next one, which was requested to be off the consent agenda, is CPC 117-14. This is an inactivation case in which the person sent us an email but refused to give us their last name or to electronically or otherwise sign their complaint. It's an allegation that an officer used excessive force while arresting a DWI suspect. This case was investigated by Internal Affairs on the own motion of the department, but because this complainant did not sign their complaint either electronically or manually, we have no jurisdiction to investigate it. I ask you to adopt the letter as written.
Okay, so I move to adopt CPC 117-14. Is there a second? Okay, did I hear one or no?
Yeah, second.
Okay, thank you. On the discussions, again, this was me. I guess I'm curious the fact that since it didn't meet the requirements of us having jurisdiction of it, we are not privy to the results of the investigation. Does that pretty much sum it up?
Acting Lieutenant Medrano is prepared to address what can be released at this point with respect to the Internal Affairs investigation.
Okay, thank you.
Commissioner Peterson, Commissioner Berger, Commissioner Foster, in this particular CPC was in fact investigated as an internal situation, and it was fully investigated. So I would not be able to speak on that investigation due to the fact that it's an internal investigation.
Okay.
You can.
So I'm clear. What you just said is it was investigated, but you're not able to speak to it. Is that right?
That is correct, sir.
Okay. Well.
But the complainant, and I'll put this in the letter, the complainant could request through IPRA whatever public record documents there are through that Internal Affairs. If an officer were disciplined, then there are documents which, under the rules of IPRA, someone could get. And so we'll explain to the complainant how he could do that if he so chose to do so.
Okay. Well, that's the information I guess I needed. There being a motion and a second. All those in favor of adopting the findings of CPC 117-14, please say aye.
Commissioner Peterson,
Aye.
we have
Commissioner Foster has some concerns.
we have some additional.
Sorry, Commissioner Foster, please.
We have some additional questions. So, are you saying, Lieutenant, that an internal request was submitted to your agency or your department in relation to this matter, independent of this person seeking information from us?
It came to the department's attention, reference this particular incident, and the department chose to go ahead and conduct their internal investigation.
And we are unable to get involved in this IRO because of our bureaucratic limitations, i.e. the person's full name, address, and signature, and et cetera.
I wouldn't agree with the bureaucratic limitations characterization, but we only have jurisdiction as granted by the ordinance, and the ordinance and the police union contract requires that the signatures be, that this only investigate signed complaints, which this was not.
Thank you. Thank you, Commissioner. Commissioner Barker, do you have something? Nope.
I believe the discussion is over, Chair.
Okay. Let's go ahead and vote on it. All those in favor of adopting the findings of CPC 117-14, please say aye.
Aye.
Aye. Was that unanimous, Commissioner Foster?
It is, sir.
Okay. Very good. So that concludes the CPCs. Hammer.
I believe that we're ready for the non-concurrence section of the agenda. The first non-concurrence case is 112-12. And this is a case in which there is a dispute downtown, and that there were an allegation that there was a fight, and that the complainant sustained injuries. The allegation was reviewed with respect to the this allegation, and I determined that the allegation to be based on false or invalid facts, and moved to or submitted a finding as unfounded against the detective. And then this is a case which was originally investigated by an IRO investigator who left the employment of the city of Albuquerque in 2012 and was reassigned to a current investigator, Investigator Scotch-DePole. When Investigator Scotch-DePole attempted to follow up on the original investigator's questions of the detective, it was determined that the detective was on military leave and not available. The original investigator had not asked the detective about whether or not he recorded the incident due to his own lack of diligence in the investigation. By the time that Investigator Scotch-DePole interviewed the detective, it was past the 120 days that re-interviewed him. It was past the 120 days that officers are required. The officer stated that, Detective W stated that if he had made an arrest, he would have tagged the video into evidence, but no arrest was made in this case. So therefore, no video was tagged. And so therefore, the correct finding should be not sustained, which is what the Chief of Police and the chain of command stated. So therefore, due to no fault of his own, but there was an independent witness to the event which substantiated what the officer said, that it was not the officers who attacked the complainant, but unknown other persons. And because they were never identified, therefore no arrest was made. And in the same way with respect to all of the other detectives, the allegation that they were the ones who inflicted force against the complainant, I found those to be unfounded because the independent witness, who had no relation to the police or to the complainant, just another patron of downtown, observed that it was unidentified suspects who fled before the police got there, who beat up the intoxicated complainant on this incident. And if, Chair, there's still questions, then we can have Acting Lieutenant Medrano explain the department's position with respect to the lapel camera.
Okay, so before we move into discussion, I'll go ahead and move to approve the findings of CPC 112-12. Is there a second? I
will second it so we can get to some discussion here.
Okay. All right. So a motion and a second. Is there any discussion?
Yes. Again, I'd like to be explained. It was sustained that the officer did not log his videotape into evidence because there was no arrest.
That he was not sustained because of that. He was required to keep it for 120 days. He would be required to log it into evidence if there were an arrest. There was no arrest, so therefore, after 120 days, the officer is permitted under the rules to destroy the tape. And this is obviously the old system. Right now, under the new cameras, they are fed into a cloud, if you will, computerized storage, so it's not up to the individual officers to download it off, basically like an MP3 player type storage unit and put it onto a disk or onto his computer. That was the old system. The new system allows downloading directly into a storage system, which the evidence department maintains. Whether there's an arrest or not an arrest, it's just downloaded. But the old system required officers to download their at the end of every shift, their recordings and keep what they downloaded for 120 days. And the officer did do that in this case, but due to the personnel inadequacies of the IRO's office, it was not collected before the 120 days were up from the previous investigator who has left the employment of the city of Albuquerque. And so when we got to him, when Investigator Scotch-Topol asked the detective, please give us a copy, it was past the 120 days. And in addition, some of the delay was attributed to the detective who was on military leave for part of that time. So the time expired of the 120 days expired for two reasons. One, the IRO investigator, the previous one, did not ask him for it within a timely manner. And secondly, in that period of time, he was on military leave, and the 120 days lapsed while he was off on military leave, excused leave.
So we don't, as soon as we get a complaint, in this case, the complaint came in, 5 days after the event, then we don't say, okay, hold all the evidence, we just went ahead and let it go for 120 days?
The previous investigator interviewed the detective relatively short in time from when we received the complaint. The previous investigator did not ask for the tape. Why he did not, I do not know. Inadvertent error, he made a mistake. He just didn't do it. And when I reviewed it, I asked for follow-up from Investigator Scotch-Topol, who is still under our employment, and that's when we determined that it was destroyed before we could obtain it. But what's important here is that there is a third-party independent witness who observed the entire incident. So it's not, some cases, we don't know what happened. It's he said, she said between the officer and the complainant. In this case, we know from an independent witness who has nothing to do with the complainant or the police, just another patron of downtown, and she's the 911 caller who called the police to say that this man's being beat up, the complainant's being beat up, and we have the records to substantiate her story as well. So in this case, the lapel camera isn't as important as it is in other cases where we don't have third-party independent evidence, and in this case we do have that.
Well, we have it. Is it a statement written somewhere?
I believe so, yes, and she was interviewed as well by our office.
Then that should have been taped.
Our office has the recording of her interview.
See, that's perfect. And this is one of those cases where, had we taped it and saved the tape, it would exonerate the officer. As we found up here, we see a lot more pluses for our officers that have taped things accurately and totally refuted complaints. And this would have been one of those had we.
Well, in this case, the officer was exonerated. It's unfounded, which means we found the facts to be false through the independent third witness.
Right, but again, our commission doesn't have that evidence, and it's like you said, he said, she said, the witness said that this happened, okay, fine.
It's the person who called 911, where we have the recording of what they were saying as contemporaneously as it was happening. It's a credible third-party witness that I found to be enough evidence to exonerate the officer in finding that the allegation was false based on invalid facts.
And I would think that if we have a non-concurrence, that evidence should have come to this tonight. If we know that we non-concurred because of not providing that information before, then certainly it should have been included this evening.
It is included in my letter, which is until there's an appeal, the amount of evidence that the commission receives.
I would have liked to have seen the video, and I would like to have heard the 911 call. And I'd like to have seen a written statement by the witness.
Okay.
But, okay, it's been moved and seconded. It's all yours, Mr. Chairman. One more question.
Lieutenant, this is for you, sir. In relation to SOP.
I'm listening, sir. Yes, sir.
If an officer is under investigation by our organization, is the officer the only person to have the code to his lapel camera to release it?
I don't understand, sir. You mean the code? I don't understand. I mean,
well, they're evidently every officer, when they download their video, they have some type of number or code that is unique to themselves, and they in turn tag it in relation to certain codes in accordance with the SOP. My question is, the officer, it was said to us that the officer was on military leave, so therefore we did not, or there was no access to that evidence.
Okay.
My question to you is the officer the only one who can release that evidence?
this will be a two-part answer. First of all, with regards to CPC 112-12, based on the investigation that I've read by the IRO's office, it appears that the officer had a lapel video camera, one that you have to activate by hand in terms of hitting the button twice. Now, with those lapel video cameras, the officer will download their video recording onto their hard drive. Okay? At that point, if they need to make a copy, then we'll make a copy and then tag it into evidence. Now, with regards to the new TASER video cameras, those are uploaded, like the IRO said, into a cloud. There are certain officers, commanders, supervisors who do have the ability, along with the officer who put it in, to view that video and to go ahead and download it and provide it. It also gives an audit trail on who's viewed that video, what actions any officer took with regards to that video. So if need be, someone could have gone into the evidence.com and request that video, download it, or go through our evidence to have it downloaded. Now, with regards to this one, it appears that it went through his hard drive, so he would be the only one to be able to provide that video if it was asked for.
When he goes on military leave, does he keep all of his departmental gear with him, or does he turn it in until he comes back from military leave?
He can turn it in, or he can keep it secured within his residence, but with the exception of the patrol vehicle would have to be placed at one of our substations or one of our fleet maintenance so that it's secured there. But he or she can keep the department-issued equipment at home.
And that includes I call them MDTs, they're called something else
Yes,
these
sir.
days. So that includes the MDT and all of his CDs.
Correct, sir. Yes, sir.
Okay, Commissioner Foster, was there anything further from you?
Do you have anything further?
I'm finished, Commissioner.
Okay, I had one question and one statement. I guess the question is, we're saying that the evidence was logged in, but since it was past 120 days, was deleted per the SOP. Is there a log that shows that it was there and then was deleted? I mean, is a record kept of what was there?
What the not sustained finding with respect to the recording is that we can't prove one way or the other. That's what it is not sustained. It's not exonerated against the officer with respect to the lapel camera. We can't prove that he recorded it. He said he recorded it, but because of the shortcomings of the original IRO investigations and the compounded with the officer's military leave, we cannot prove it one way or the other. So it's not sustained.
Right. So that was the question. Then I guess the statement part is you refer to the neutral third-party witness, and that's why, you know, the officer's exonerated and stuff. And I agree on the other SOP items that helps in clarifying he said, she said. But with regard to the lapel camera video, the third person is not even a factor. I mean,
that's correct. With respect to the lapel, the third party, the independent third party, is not did not weigh into my decision. What weighed into my decision is, can we prove that the officer didn't do it or not? No, we cannot, unfortunately, because of two things. The military leave, which the officer was approved for, and that by the time he got back from leave, it was past the 120 days.
Okay. So this is a tough one for me. Obviously, the officer shouldn't be faulted for being on military leave, but at the same time, he shouldn't be exonerated because the IRO's office, the investigator at the time, didn't do his due diligence. So,
but I'm not exonerating him. I'm saying he is not sustained, which means we can't prove it for two reasons. One, the military leave, and two, the initial interview, which was done before he left on military leave. The IRO investigator at the time did not ask the question. So we have no evidence one way or the other. And he's not being exonerated, and a not sustained on a personnel file is a different finding and treated differently than an exonerated.
And so, IRO, with that, there is no conflict between the chiefs, the APD, and us. Is that correct?
That between the chief and myself, yes.
Yes. So when we are going to take a vote, we are taking a vote to accept your amended documents along with the explanation when it goes back to the chief?
It would just go back to the office. Well, the letter would be sent out to the citizen, and the file would remain in internal affairs for the officers, the subject officers' internal personnel files.
Ms. Hammer, can you repeat Commissioner Foster's question for me? I can't hear what he's saying.
He asked what happens now and what are you voting on. Is the vote to the chief of police agrees that it should be not sustained, and so the chief and I are in agreement with my amended letter, and that was his question.
Okay. So is there any further discussion? Okay. So, again, I would ask the commissioners speaking to their microphones on this one, but all those in favor of approving CPC 112-12, please say aye.
Aye.
Opposed would be me. So that was 2 for, and 1 against. Does that sound right?
Well, is this letter going to be amended?
Yes.
And Commissioners, I would like to see the amended letter come in front of us before we vote, but we've already started that process. So my vote is a no.
Commissioner Barker was for, Commissioner Peterson and Foster against.
So what I would suggest, under our rules, the POC must approve the letter before going to being sent, and so the letter could be amended to reflect that the POC disagreed with the findings of the chief and the IRO, but approves the letter as to form. You have to approve the letter in some form before it can be sent. Otherwise, this person will never hear what happened.
I believe we have the option of sending it to the mayor's office.
No. It has to be sent to the citizen, and if the citizen appeals, then you can hear the appeal. And if the citizen doesn't appeal, then you can send it to the mayor's office. But the first thing that has to happen is the letter has to go out. And so the letter under, I believe, what your suggestions or decision is that the letter goes out and says the POC disagrees with the findings of the chief and the IRO and approves as to form.
And that puts the ball back in their court. My main concern here is when folks have appeals and non-concurrences, we should provide as much information as possible so as to avoid any perception of collusion between the IRO's office and this commission. And so when we come in here and say, okay, what's the penalty for beating up a prisoner or a citizen, and what's the penalty for not having your camera on? Okay, let me guess this one. But then when we have a witness, then we can feel a lot more comfortable in deciding in favor. You see what I'm saying? If we just sit here and the IRO comes in and says we have preponderant evidence here that says that this is what it is, I would like to have that evidence shared with us when there's complaints, and especially non-concurrences.
The rules and the ordinance, the current ordinance provides, and the union contract, which is, there are the three things that govern how we operate, state that the POC does not receive the investigative file other than through oral testimony unless there is an appeal. And so we need to put the letter out there in all cases to give that decision to the appellant, the person who's complaining, whether or not they're going to appeal. And if they do appeal, then you get the investigative file. Without an appeal, you get live testimony from myself and the representative from the department. Other systems may be better or different, but that's the system we have right now.
Okay, well, Mr. Du Bois, I think we have an issue here in that we voted. We had a motion and a second, and we voted, but now we are faced with back to where we were some months ago, in that we have to approve the letter in form but disagree with the findings, but we already have voted. So how do we handle that? Somebody lend the man the microphone.
I would suggest a new motion indicating that the letter be approved as to form only, and then see how that vote goes.
Okay. Well, I will do that. I move to approve CPC 112-12.
To clarify as to form only, based on Commissioner Foster, that means that the form of the letter is correct, that the IRO's statements of her position and the Chief of Police's position is correctly stated.
Right. Okay. So then again, I make a motion to approve CPC 112-12 with language added stating that this letter is approved in form, but the Police Oversight Commission disagrees with the findings. There's a second.
Second.
Okay, now any discussion on that? All right. Hearing none, all those in favor of approving CPC 112-12 in form with the added language, please say aye.
Aye.
Aye. Okay.
The next non-concurrence case is 41-13. This is a case that we heard last month, and there was concern by the commission about my findings. It involves a case of a neighborhood dispute, and there was a sergeant who responded to the neighborhood dispute about where cars were parked, and in her report, which was written at the time, the sergeant noted that her camera was not working as required by the SOP. The SOP says that if you note in the report contemporaneous with the failure of the camera to work, then you have complied with the sections of the SOP. And so therefore, I found, with respect to improper conduct, the allegation that she cussed, that the sergeant cussed or acted officiously, cussed, I found not sustained. There was no evidence in any way to support that the officer permitted her own feelings to influence her decision. And with respect to the lapel, I found, and the chief agreed, that the sergeant should be not sustained because she did comply with the requirement that she note in her original report, written at the time prior to ever knowing that a complaint was filed against her that her camera failed to work. And I believe Lieutenant Madrano could address the department's position on this case.
Commissioner Peterson, Commissioner Foster, Commissioner Barker. With regards to CPC 041-13, after reviewing this, it appears that the SOP that we were looking at, or what the sergeant was charged with possible violation was 1-39-2B. With that, it states that all sworn department personnel will record each and every contact with a citizen during their shift as a result of a dispatch call for service, arrest, warrant, search warrant, service, or traffic stop. Personnel will activate the recorder prior to the arriving of the call or prior to the citizen contact or non-dispatched events within the safety parameters of 1-39-1B and will record the entirety of the citizen contact. Uniformed civilian personnel issue digital recorders will also comply with this section. The recordings will be saved for no less than 120 days. Now, the SOP I just read to you is the SOP that the sergeant is particularly charged with. The one that Ira Hammer discussed was 1-39-2C, two different parts of the SOP. Now, the chain of command not sustained the sergeant. So I'm having a difficulty time. I can't speak with regards to 1-39-2C because she wasn't charged with that. She was charged with 1-39-2B, which states that she will activate her recorder. Now, based on her the investigation that was done, the sergeant, when she made contact with the citizen, she activated her lapel video camera, which she thought she did. She conducted her investigation. Once that investigation was done, or actually part into it, she realized it was not recording and tried to hit it again. Now, with regards to that, our position with the department would be that she be not sustained because she did what she was supposed to do. It's the recorder's fault for not recording if she went and activated it. So with regards to 1-39-2C, I can't speak to that because she wasn't charged on that.
If I could explain, I would say that because she did comply, she wasn't charged with violating C. She was charged with complying, or because she could complied with C, which says personnel issued video recorders that malfunction will contact their supervisor immediately to arrange for replacement. The malfunction and the replacement of the recorder will be documented in the applicable report. And that's what she did, was she documented in the report at the time that it was written. She wrote the report that her camera malfunctioned and she had contacted her supervisor. So because she complied with Section C, which provides provisions of what you do if you know immediately that it's not, your camera's not working, which is, therefore she did not violate, we could not prove, there was not enough evidence that she to prove that she violated the failure to record, because she complied with the SOP that provides for malfunction. There are times that we get people who are officers who are charged with not recording, who come in during our interviews and say, well, I thought it worked, but it didn't work. But they didn't write it in the report contemporaneous with it. And on cases in which the officer has complied with the section that says you write it in the original report, which gets filed that day, in the police report that your camera didn't work, there you do not violate the lapel camera section 1-39(2)B. And in this case, she did do that.
Yeah, your comments are very enlightening, but the written word doesn't stipulate immediately or at the end of shift. The SOP says that she's got to report it immediately, and your statement says she documented in her police report that her camera failed. Well, when did that happen?
At the time of the incident, when
Okay,
she was at the time. And it says the malfunction and the replacement of the recorder will be documented in the applicable report. She did do that in this case. As opposed to other people who, after the fact, a month later, say, my camera didn't work. This sergeant, at the time, documented it on the day that it occurred, at the time that it was occurring. At the same time she was writing in her report what happened with respect to the incident, the dispatch call for service, she also wrote that her camera malfunctioned. And in those cases, we have always found, or I've always found, because it is the provision within the SOP, if you comply with the reporting of the malfunction immediately, then therefore you're in compliance with the SOP.
Lieutenant.
Sir?
So are you saying there is more than one section in the SOP in relation to the video camera? Because you were talking about one where it's very specific, saying that any and all incidences shall be recorded. So, but then there's an out, it appears, that if the officer, for whatever reason, his camera is turned off, that they get a pass if they write it into the report that the camera malfunctioned. Is that what I'm hearing you say?
Commissioner Foster, I wouldn't even say it was a pass. I would say that she was complying with the SOP. She realized her recorder was not working, notified her supervisor, documented it as per SOP. If she didn't do that, then she would be in violation of that SOP. So I would say it's not a pass. I'd say that she did what she was instructed and what she needs to do.
And I would point out in the letter, it says, the policy refers in 2 sections that if the officer checks the equipment, documents the failure in the report, and gets a timely replacement, there is compliance. While the letter does not specifically cite 1-39(2)C, that's what that sentence is referring to, is that the officer complied with the provision about reporting the malfunction, and therefore she was in compliance with the SOP.
Okay. Two things from here. The first is, if there's any possibility of someone giving Commissioner Foster a different microphone to speak into, that would be awesome. The second thing is, I'm siding with Commissioner Foster on this one, in that nothing has changed since the last time we heard this, as far as I can tell. I mean, my issue with this is that Ms. Hammer's using the term, well, she noted it immediately. Well, immediately, she noted it when she was writing her report. That's not immediately. And what that does is allows by Commissioner Foster. So that allows anybody to say, okay, you know, here's how this went down. Oh, and by the way, I'm making a note in my report now that my camera was not working. That doesn't help anything. So, Ms. Hammer, refresh my memory. We heard this case last month. Now it's on the non-concurrence. Are we giving it another shot and voting to see if we vote differently on this time around?
I think that you voted yes, to see after further explanation if you have a better understanding of why myself and the department found that the officer was in compliance when she wrote the report.
Okay.
Officers are required, and the lieutenant can address this as well, but officers are required to write their report before the end of their shift. So within her 8 to 10 hours of working, this was done. And so why she might not have written it the second it happened, she wrote it before the end of her shift, that she noted that her camera did not work, and she contacted the supervisor as required by the SOP. And the SOP does not require immediately. It says that the recordings be in the report, but there's a separate SOP, which I did not refer to, which requires the report to be written before the end of their shift.
Okay. All right. So we've kind of skipped ahead to the discussion, but I'll go ahead and move to approve CPC 065-14. Is there a second? I'm not hearing that. Still not hearing that.
So I would say that if there's no movement to approve the letter, then you need to make a second motion, as Assistant City Attorney Du Bois suggested last time, that you approve as to form, so that the citizen may understand what happened in her case.
Okay, so then let me amend my motion. I move to approve 065-14 with language added that the letter is approved as the form, but the POC disagrees with the findings for not sustained with the use of lapel camera.
Excuse me, Commissioner
Second
Peterson.
on that.
Commissioner Peterson, what was that CPC once again, please?
The CPC is, 041-13.
-14. Oh, yes, 13. 4113.
Commissioner Peterson, I second that.
So that was a second. Okay, so I got to be careful what I wish for. I asked that Commissioner Foster get a new microphone. Now everything sounds differently. But, okay, so there's a motion and a second. All those in favor of approving CPC 41-13 with language stating that it's approved in form, POC disagrees with the findings, they say aye.
Aye.
You can say
Aye.
You don't have to come back and forth.
That's unanimous.
Yes, I said aye.
So is unanimous. The next case is CPC 65-14, which is a case in which it involves the Golden Corral restaurant. He said that he was searched, that the person was arrested, that his backpacks was searched, and that the officer threw away items which the complainant found of value. I found that the officer should be not sustained for the discarding the personal property, and that the officer should be sustained for recording the incident because he did not record the incident of the citizen in every contact with the citizen during their shift in its entirety. And this was a dispatch call for service. And this is a case in which it's not the disagreement between myself and the commission, it's a disagreement between myself and the department. The chief of police believes that the officer should be not sustained and Acting Lieutenant Madrano can explain the department's position on this.
Commissioner Peterson, Commissioner Barker, Commissioner Foster, with regards to CPC 065-14, our position, or the department's position, is that SOP states that all sworn department personnel will record each and every contact with a citizen during the shift that is a result of a dispatch call for service. At the time that the officer was dealing with the individual's belongings with regards to whether or not they could be taken into MDC, the officer had his recorder off. At that point, he did not have contact with the citizen he was dealing with. So at that point, he was not in violation of the SOP with regards to having contact with him. If he was to have further contact with him again, then at that point he would turn on his lapel video camera. But at the time he was looking at the belongings of the citizen, he did not have contact with him. The citizen was actually in the back of his patrol car, and he was outside of it. So our position would be that he did not violate that SOP, and also, if you want to look in further, it doesn't state anywhere in the SOP that where if an officer is going through an individual's belongings as regards to an arrest and then going to place them whether into evidence or into MDC, that he or she has to have their lapel video camera running.
Okay. So I move to approve CPC 065-14. Is there a second?
I'll second it so we can discuss it.
Okay, that's second. So is there any discussion?
There is discussion. Lieutenant, so when an officer is on foot, he does have a handheld, and when what does the SOP say in relation when an officer who is on foot makes contact with a citizen? Do they not report, one, their position, and two, that they are making contact with a citizen? Because if that is what standard procedure where I come from.
So I understand correctly, sir, Commissioner Foster, that if an officer is on foot patrol and comes in contact with a citizen, they are to record that contact. Am I understanding that correctly, sir? SOP states all sworn department personnel will record each and every contact with a citizen during the shift as a result of a dispatch call for service, arrest warrant, search warrant, service, or a traffic stop. So if they're on foot patrol and they make contact with a citizen, they do not necessarily need to record that contact. Now, I mean, there will be situations that the officer would need to turn their camera on if they become in contact on foot patrol, and some of those would be like resisting arrest, disorderly conduct, refusing to obey an officer, domestic violence calls for court purposes. It just depends on the situations. But if it's not a dispatch call for service, then they don't have to turn on their recorder.
Well, but it's an officer safety issue. If I'm out of my car and I'm out there making some type of inquiry, I have to let the dispatch know where I am, just for my safety issue.
Correct, sir.
So that goes through dispatch, does it not?
Well, an example would be if you're doing an inquiry into a vehicle that's abandoned in the middle of a field, that's a possible stolen vehicle, and there's no one around, then I can see where an officer doesn't have to turn on his video recorder, but still would have to advise the dispatcher where he's at just in case.
When you make a traffic stop, when you make a 54.
Correct.
You're not only doing a 54, but you're also doing the location.
Correct, sir, but at that point, that's a traffic stop, and by SOP, they do have to turn the recorder on.
So if it's not something that is, and I don't want to belabor this, but if it's not something that dispatches them to, then that officer does not have the obligation to turn on their recorder.
They're not required to turn on the recorder, but, I mean, speaking for myself, based on the situation, it would depend on, you know, whether they turn it on or not. But per SOP, they don't have to turn it on if it's not a dispatched activity, traffic stop, and arrest warrant or search warrant service. Yes, sir.
I'm going to go ahead and speak because Commissioner Foster may be speaking, but I wouldn't know because they can't hear him. I guess the issue I have with the discussion that just took place is this wasn't a casual, hey, what's going on over there? I mean, he was arresting this guy. I would think that if you're placing someone under arrest, that would warrant using your lapel camera, and apparently it did because he had it on. My issue is that, let's see, Officer H could not remember specifically what he threw away, but thought that whatever he threw away would be captured on his lapel video. Officer H turned off the recorder prior to the disposal of the item, so it was not captured on the video. The way that reads to me is, I turned off my camera before I threw the stuff away, but I would think that anything I threw away was captured on my video. Those two don't jive. Commissioner Barker, did you want to chime in on this?
I saw this as another opportunity for an officer to totally cover himself by having that camera on. And by turning the camera off before he disposed of things, he just opened himself for question.
And that's what my letter reflects. And so if there were to be a motion to approve the letter, it would be to approve the position that you just stated, Commissioner Barker. My letter is written that the officer be sustained. The dispute between myself and the chief is record every contact. Does contact mean only when you're talking to the person, or does contact mean, it says contact with a citizen. Does contact mean the entire event from when you were, this was a dispatch call for service, from when the time you're dispatched until you place the person at the prisoner transport unit? Does that constitute contact, which is what my position is, or does it only that rule only cover when you're speaking with the citizen, the person you're arresting? And so that's the dispute between myself and the chief, but my letter sustains the officer, i.e. finds a violation for him not recording the entire incident, which I would consider the incident to be considered the contact within the SOP.
Okay. Is there any further discussion?
No.
And what I'd like to do is amend my motion. I know there was a second. I'd like to amend my motion to read, to move for the approval of 065-14 with language added that the letter is approved in form, but that the POC did not agree with the findings regarding the lapel camera.
If you're not agreeing with the findings of the IRO, that means you're agreeing with the chief, who's disagreeing with me, to say that the officer should not be held accountable for this. In this case, the question is, to approve the letter means you're agreeing with the IRO, myself, who has found that the officer failed to follow the rule. The officer was sustained by me, and if you look on page 3, it says, Chief Eden did not agree with these findings regarding the use of the recording devices. To reprove only as to form means you want the officer to be not sustained and not held accountable for failing to record the incident.
Got it. Got it. My bad. Okay, so then the motion being amended yet again is to approve 065-14 with language added that the letter is approved in form, but that the POC did not agree with the chief's finding. Well, it's not the chief's finding, but the
or
the
you
chief.
could approve the letter, period, and the chief gets to disagree. That's the letter says that the IRO has found that the officer should be held accountable, and the chief is disagreeing.
Okay.
If you approve the letter as written.
So we're just approving the letter as written, and that makes it much simpler. So That would be the fourth and final, I hope, amendment to my motion that I move for approval of CPC 065-14. Is there a second on that?
Second.
Second. All those in favor say aye.
Aye.
Aye. Okay, that's unanimous. So next on the agenda is the police shooting case I-199-12.
The police shooting this case, I-199-12, involves an incident in which two officers were called to a domestic dispute, a domestic violence incident in which people observed a woman allegedly being beat up by a man. When the two officers arrived at the scene, they saw a man that matched the description and asked him to come to their direction, and he started retreating from the officers. As the officers approached the house that the suspect was retreating into, they saw that there was a pit bull, a medium-sized pit bull, in there. As the pit bull aggressively moved toward the first officer, Officer S, fired at the pit bull, striking at one time. The second officer then was in the area, and the dog was injured but not dead at that point, and the dog bit the second officer, Officer P, in the finger. I reviewed the investigation that was done by the Albuquerque Police Department in this shooting, and made a finding that the officer's use of deadly force against the dog was in compliance with the SOP, and that he had immediate fear of death or serious physical injury. And I have some photos to show. This is the street. This event occurred at night, and this is the street that the officers were walking up as they were approaching the home where the dog was sitting outside of. This is the car. You can see the home is behind this green car in this scene, in this photo. This is the front of the home. Between the red car and the green car is where the dog was. Ultimately just died. And that's the front door of the home that the officers were trying to approach. And you can see between the red car and the green car towards the front door is where the dog was at. And there's a better picture of the dog. It was a rather large pit bull dog. And here's a picture of where the second officer was bit on the finger by the pit bull. And Lieutenant Medrano was the internal affairs investigator who conducted the investigation in this case, and he would be here if there were any questions. And he's available for answering questions.
Commissioners Foster, Barker, do you have any questions? No, hearing none. Okay, was there anything further, Ms. Hammer?
No, nothing further.
Okay, so I move to approve the shooting case I-199-12. Is there a second? Any further discussion? Okay. All those in favor of approving I-199-12, please say aye.
Aye.
Aye. Okay, so I couldn't hear anybody else, so I'm assuming that was unanimous.
That was unanimous.
Excellent. Okay, thank you for Commissioner Foster, why don't you give us a wrap up on the long-term planning committee? Just kidding.
We had a wonderful time, Commissioner Peterson.
Okay. Let's see, reports from city staff, IRO.
During the month of July, we received 22 CPCs, opened 22 new cases. We also received 18 job well dones, which the summaries of all job well dones received in July will be contained in the July minutes. We resolved last month 12 cases, I believe, by the POC at our last meeting. Actually, I think there were a few more than that, but there were all those cases which were resolved are reflected in the minutes, which were just approved. And we are working with city staff to get the minutes and the agendas and relevant documents to be contained on the Legistar system, which is the same system that City Council uses to display to the public all of their meeting agendas, minutes, and legislation. It's been a process many years in the making, but we're having meetings within the next few weeks to hopefully move forward in putting the POC's documents onto the Legistar system so that citizens will have a better understanding and access. People would not have to do an IPRA to receive the minutes. They would readily be available from the comfort of their home. This coming Monday, the City Council is slated to hear whether or not they approve the continuance of the current Police Oversight Commission, and also that's August the 18th here at City Council chambers beginning at 5 o'clock. Also slated to be on that agenda is proposed changes to the POC ordinance, which I believe have not been, there is a floor substitute, which is the current bill, but there may be further revisions which will be heard on this coming Monday night at 5 o'clock, in which the public is welcome to comment at that time to City Council and any future changes. With that, I'd stand for questions.
Commissioners Foster and Barker, any questions for the IRO?
There were no questions.
Okay, thank you, Ms. Hammer. Investigator Scott DePaul, SOP updates.
Chair Peterson and Honorable Commissioners, my name is Paul Scotch DePaul. I'm an investigator with the Independent Review Office, and I sit on the Policy and Procedures Review Board. We did have a meeting on July 17th of this year. The meeting, however, we did not discuss any standard operating procedure changes, but simply discussed a possible revision to the Policy and Procedures Review Board and its constitution. And that's all.
All right. Is there, Commissioner Foster or Barker, is there any questions? Investigator Scott, thank you very much.
Thank you.
The mayor's staff.
None are present.
Not present. City council staff.
None are present.
Not present. City attorney staff.
Esteemed council is present.
John Du Bois with the City Legal Department. I have nothing to report. I do just want to say that this may be our last meeting together. And if that is so, I want to say that, you know, I've reserved my praise for what I call the three who stayed and not the three who quit. And it's been a real pleasure serving with you, if that's what it turns out to be. And that's all I wanted to say, and I'll stand for any questions.
No questions from me, Commissioners Barker or Foster.
No questions.
Okay, Mr. Du Bois, thank you very much.
Thank you.
APD.
Chair Peterson, Commissioner Foster, Commissioner Barker. My name is Sergeant Medrano. I'm the Acting Lieutenant for the Internal Affairs Unit. Reference dispatch calls for service for July of 2014. There was 44,803. Internal cases for the month of July 2014. Internal cases received, there was 13. And as at the end of July 31st, 2014, year-to-date was 129. Internal cases inactivated, 1. Internal cases mediated, none. Total internal investigations completed the month of July 2014, 12. Discipline on internal cases for July 2014, 1 counseling, 5 verbal reprimands, 4 letters of reprimands, 1 80-hour suspension, and 2 terminations. Pending cases for the month of July 2014 are 12. And I will stand for any questions, sir.
Commissioner Foster or Barker, any questions?
I have to go back to our earlier appeal, you came up with some very germane information that was of interest and solved the issue with regard to Mr. Arison's appeal. And I wish that had been more forthcoming earlier, because it would have resolved a lot of these issues. And I appreciate you bringing that information to the table, and look forward to a long, relationship until Monday.
Thank you, sir.
I've got no questions, so thank you very much.
Chair Peterson, could I expand upon Commissioner Barker's statement?
Absolutely.
In the letter that was sent to Mr. Aronson in December of 2013, that information was relayed to him as to what the department had done. Certainly in my statement made to explain the findings of the IRO and the chief. In that information was given to him and to the commission in March of this year when the appeal was first filed. And so it was a memo that was written by a deputy chief as to what he had done to resolve the complaint. And I'm sorry that Mr. Aronson didn't fully understand what he had before him, both in his letter, his explanation from myself in December of this year, I'm sorry, of 2013. But in the end, what happened is that a complaint was made, a problem was brought to the attention of the department, and the department resolved the issue. That's the bottom line in this case.
Understood. Appreciate the information. So, I guess we're on to other business and commission recommendations. Mr. Du Bois alluded to the fact that this could be our last dance. I'm going to just say that it will more than likely be the last dance for me either way, depending on what the city council decides. Maybe moot for myself because I have taken up residence, or not yet, but by the time of the next meeting we'll have taken up residence elsewhere. So I don't think I'll be able to do this one next month. So with that said, I would like to commend everybody in this process for the jobs they do. I think it's been a fruitful effort. I appreciate everybody bringing what they bring to the table. We've had some good discussions, don't always agree, and I think that was the intent. To the IRO's office and her investigators, kudos on getting in there and getting with it. To the other commissioners that stuck it out, thank you. It wasn't easy. Then to all the staff and everything, just thanks for letting me be a part of it, and I appreciate the experience, and I hope that you're nothing but the best with this process moving forward. So, since I can't hear any of you other commissioners anyway, I guess I won't give you a chance to say anything. I guess that is it. We'll go ahead and adjourn this meeting. That is at What's that? 17:45. Over and out.
I never expected a sailor to cut and run.